Hi, I'm Sylvia Mayer. Thank you for clicking on Mayer on Mediation and Arbitration. Today, I want to talk to you about the error of making assumptions in arbitration. Now, you know what they say about when you assume, right? Well, it is true. As an arbitrator, I see 4 common assumptions that can negatively impact an arbitration. These assumptions involve acronyms, informality, discovery, and damages. So let me go through each of those. Acronyms. You may be immersed in the case. You may have lived this case for months or a year or more, but the arbitrators have not. So do not assume that we have the same level of understanding that you have. Do not speak in a word salad. Make sure you set the stage for the arbitrators on the basics of who is involved, what is involved, and the terminology. I used acronyms as an example because I had a case where during oral argument, one of the attorneys launched into an argument that was filled with acronyms and shorthand references. And after a few minutes, one of us on the panel stopped and said, "You got to back up. We have no idea what you're talking about." He did. He fixed it. He got us on the same page with the terminology. But it was a good example of how you're living it, but you got to bring me up to speed too. Informality. Yes, arbitration is not as formal as litigation, for example, federal court litigation. But that does not mean that you should not be prepared. Do not assume that informality means you don't have to prepare. You do need to prepare. And where this plays out the most is at the initial scheduling conference. The initial scheduling conference is a really critical part of every arbitration, and you need to come prepared to that. You need to come prepared to address timing and to address any issues that we need to be thinking about as we're moving the arbitration forward. Discovery. Arbitration is designed to be fair, efficient, and economical. So there may be discovery in arbitration, but it will not look like the discovery that you would take in a state or federal litigation. One of the beauties of arbitration is that we can tailor discovery to fit each individual case. I'll use as an example interrogatories. As a general rule, I do not allow interrogatories, but that doesn't mean that there aren't exceptions to that rule. So I routinely in an initial scheduling conference will say to the parties when we're talking about information exchange and discovery, as a general rule, I don't allow interrogatories. Is this a case where you need interrogatories? And I'll give you 2 different examples of how that has played out. In one case, the parties responded and said, "We have actually litigated similar issues across from each other before. And we have a pretty standard set of interrogatories that are tailored to this particular unique issue and these types of facts. And we find it's more efficient if we use these interrogatories, and we're in agreement." I said, "Great, let's use those interrogatories. It makes sense for your case." In contrast, I had another case where I said, as a general rule, I don't allow interrogatories. Is this a case where there's an exception where you might need interrogatories? And there's a very long pause. And then one of the parties chuckles and said, "Habit?" And the other attorney chuckled and said, "Yeah, me too, habit." And so I said, "Okay, well, other than habit, do you need interrogatories?" Another long pause. And then both said, "No, we really don't need interrogatories in this case." So we didn't do it. So keep in mind that you should not make assumptions about what the discovery will look like in the arbitration, because it's not going to look like what you do in state or federal court litigation. Lastly, damages. Make sure you specify how much, how it is calculated, what the basis is for that calculation and for the award of damages. So often parties assume that they can encapsulate it and put it in a nutshell, and that's sufficient, but it's not. We need to understand what you want, why you want it, how you got it, and the justification for it. I also see a lot of times that parties are so focused on liability that they spend less energy and time on damages. But it's critically important if you want to actually recover any damages. So don't make assumptions around damages either. Thank you for joining me to talk about the negative impacts of assumptions in arbitration. Just remember, you know what they say about when you assume. If you have any questions, please comment below.